Namaste, good morning. Welcome to 133rd episode of AAA Weekly Webinar Series. The subject that we chose today is the latest Supreme Court and High Court judgments on SARFAESI law. As I always say, that over the years, the SARFAESI law has actually become more cleaner, less litigation. There are a lot of Supreme Court judgments which actually have done a wonderful amendments and wonderful changes in the law, and the recovery is much faster in the SARFAESI law. So, Ankit, I think while I already welcomed our see, even maybe before we even conclude the Diwali, that actually would be next session. So we would like to wish happy Diwali to our viewers and listeners. So it is you to add something, because the SARFAESI law, as I said, is much cleaner and much faster, and the litigation has reduced significantly in the SARFAESI law. So we are on SARFAESI law today. Yes, okay.
No, very much. Welcome everyone to this webinar and wish you a very happy Diwali. We all, spend Diwali. It's a culture to clean up, to clean up everything during Diwali. And I believe that we have seen SARFAESI getting cleaned up, getting finalized, the process is getting finalized over a period of as many as 21 years. So this law came in 2003 and we are sitting in 24. But yes, we at the same time see IBC as a new law where a lot of jurisprudence keeps coming up, the law keeps getting clarity. We also see that unlike other laws, we see in IBC because this is something which is not only new to India, it is also new to the world as a concept. Therefore, it has to be customized, has to be, adjustments have to be made based on the cultures and the processes of every country. So yes, IBC is also getting cleaned, and SARFAESI is already, a step further. So I think this Diwali we can all, of course, commit ourselves not only to clean up our houses, but also to, participate in cleaning up and making sure that IBC also performs, as good as SARFAESI, which is, the way it is performing today for banks.
SARFAESI law in this episode 133. Ankit, your video was freeze for some time. You want to say something? You were saying something?
No, I think we can move forward.
Okay, so what triggered? In fact, there was a judgment on recently on 16th of October 2024 from Honorable Supreme Court in the case of IDBI Bank Limited versus Ramasavaru Dalia. And this is a landmark judgment. So therefore, we thought that why not have a complete episode, as we've been doing earlier also, on latest judgments primarily from Supreme Court of India, and also then we'll cover, in case we have some time, regarding the High Court judgments, and also for even some DRAT judgments. So this judgment is from Honorable Supreme Court. It is from Justice Pankaj Mittal and also from Justice R. Mahadevan in the case of IDBI Bank Limited versus Ramasavaru Dalia. So in this particular case, the e-auction of the disputed property was conducted on April 10 following a notice, and then the highest bidder deposited 25%. And then in the meantime, a stay was issued on 18th of April 2018 against the auction after one of the grunter challenged it. And also there were some additional hurdles. The Enforcement Directorate also issued an advisory in June 2018 asking the bank to retain property documents. So the balance amount by the auction buyer could not be deposited on time because of these legal hurdles, and therefore the bank, in fact, unilaterally, without giving a notice to the auction buyer, cancelled the auction and returned the deposit. So therefore the IDBI Bank said that the bank they said that the balance payment was not made by the auction buyer as mandated by Rule 9 Sub-Rule 4 of the Security Interest Enforcement Rules 2002. They also claimed that the High Court erred in directing the issuance of sales certificates, citing statutory compliances with Rules 9 Sub-Rule 4 of Security Interest Enforcement Rules. Then the applicant said that they could not deposit the uh, amount because of the hurdles created by Enforcement Directorate and also some CBI complaint. And therefore, because of these obstacles, it was beyond their control. Now, the legal issues, in fact, so why I'm saying this particular case is very important, because there are many cases under SARFAESI law where the auction buyer is not able to deposit the balance amount as per Rule 9 of the Security Interest Enforcement Rules. Now, the legal issues which actually identified by Honorable Supreme Court was the interpretation of Rule 9 Sub-Rule 4 of the Security Interest Enforcement Rules 2002, and also whether the stipulated period for the balance payment is absolute or can be extended by mutual agreement, and further, due process in auction cancellation. What should be the due process in auction cancellation? Whether the bank unilaterally can cancel an auction without notice, that is also something which is the issue. Now, as I said, that the what finally was held by Honorable Supreme Court is the 15 days period under Rule 9 Sub-Rule 4 was not absolute and could be extended with mutual consent. As per the respondents had shown readiness to pay and the delay were due to the bank's actions, the court found no default by the respondent. Further, the court ruled that the auction's unilateral cancel, the bank cannot cancel the auction unilaterally without giving notice to the auction buyer. That is also like devoid of natural justice. The court therefore directed that the sales certificate may be issued to the auction buyer and the balance payment will be made within 4 weeks. Now, let us understand this particular judgment. This is actually because see, the 15 days period which is mentioned in Rule 9.4, that is something which is mandatory right from the beginning. But if there can be a different period as maybe jointly uh, consented by the parties like the bank and the buyer, and then the auction cannot be cancelled without giving a notice to the auction buyer. So therefore, what is the first right of the buyer? That the bank cannot cancel simply because there is a delay in making payment of the balance amount. Second, before cancellation of the auction, the bank will have to give a notice to the auction buyer and also giving some time to him that this, yes, that we will wait for only these days and after that only we would be able to cancel it. Three, that this 15 days period is not mandatory, it is subject to the mutual consent of the parties. Therefore, this particular judgment is very important. It will resolve many disputes under the SARFAESI law, under the SARFAESI auctions. Now, while this was the trigger, we also analyzed many other Supreme Court judgments, which was either given in like 2023 or 2024. So some of the judgments that we found are really relevant for our audience. So we actually came with the analysis of these judgments. So this one such judgment is Siddha Neelkant Paper Industries Private Limited versus Prudent ARC Limited. The date of this judgment is 5th January 2023, and this is from Justice Mukesh Kumar Rasik Bai Shah and Mrs. Justice B.V. Nagaratna. So in this case, the Siddha Neelkant, in fact, took some cities from Andhra Bank, which was later assigned to Prudent ARC. So basically, Prudent ARC is acting on behalf of Andhra Bank. So there was a default, and then the SARFAESI action was taken, and the auction was held, and the sale proceeds were deposited by the auction purchaser. Now the borrower challenged the sale, simultaneously sought to adjust the auction. Now the sale proceeds were deposited. Sale proceeds of the property was deposited with the bank, so the bank's total outstanding came down. When the borrower challenged the sale before DRT, there is then there is a requirement of deposit before you file an appeal against the sale. But that pre-deposit requirement, which is under Section 18 of the SARFAESI Act, before filing an appeal, before DRAT, what the borrower did, the borrower in fact uh, calculated the deposit, that the original amount as per bank minus the amount received by the bank. So that is what was shown as the total outstanding, and the borrower deposited a percentage of fixed deposit, which is 50%, that was on the debt due. So the borrower said that the debt due is the total amount minus the sale of the property. So the 50% was deposited, and therefore the appeal was filed before the DRAT. Now, what we are saying, that the main issue in this case was, that whether this amount which is received against sale of the assets, whether this amount which is received against the receipt of the asset, that can it be adjusted? Can it be adjusted? That is something which was the case here. So I'll just take 1 second. I'll just take 1 second. Yes, so therefore now the adjustment is required or not. So therefore the court finally held that the court finally held that when calculation is done for pre-deposit, the amount received against the sale, which is being challenged by the borrower, cannot be reduced. So therefore, for the purpose of calculating 50% of the deposit, it is not possible to reduce that amount. So therefore, what we are saying, this is also a kind of judgment, landmark judgment. A borrower tried to challenge the sale on one hand. On the other hand, the borrower also reduced the amount of the auction purchase consideration from the total debt. So the both are not acceptable. Unless the borrower accept the sale, the debt would not be reduced. Therefore, 50% of pre-deposit requirement will not give this reduction option to the borrower. In another appeal from Supreme Court of India, a judgment in the case of Pro-NITS versus the Board of Directors of Canara Bank. This is from Justice Bela M. Trivedi and Justice R. Mahadevan. Now, this Pro-NIT is a registered MSME enterprise, got an assistance from Canara Bank, and the loan became NPA, and the SARFAESI action was taken. Pro-NIT, the MSME unit, in fact, challenged the bank's action on the ground that the framework for revival and rehabilitation of MSME, which was notified by MSME Ministry on 29th May 2015, it was not followed. Now, what is that framework for revival and rehabilitation of MSME? That is where the banks are required to categorize the MSME units the borrower.
I think there was a brief disconnection. You can resume now.
Okay, is it okay now?
It's okay now.
So, could you hear this MSME judgment, which is of pro nit?
Yeah, you were just starting about it. It was only a 1 minute cut, so you can just resume from there.
So, pro nit is an MSME unit and took a loan from Canara Bank. It became NPA and the SARFAESI action started. So, pro nit, the MSME unit, in fact, challenged this particular securitization action on the ground that the framework for revival and rehabilitation of MSME, as notified by Ministry of MSME on 29th May 2015, was not followed, and which is this particular framework was notified under Section 9 of MSME Act, so it was not followed. So therefore, the entire process of declaring the account as NPA was not correctly followed. So therefore, the account should not be considered as NPA, and if the account is not NPA, then SARFAESI action cannot be taken. Now, the issues under this particular case that was framed by Honorable Supreme Court was whether the framework for revival and rehabilitation of MSME as notified by the Ministry of MSME under Section 9 of MSME Act was binding on the banks and secured creditors, whether the classification of the appellant's account as NPA without following the framework was valid under the SARFAESI Act. Now, these particular issues, in fact, the Honorable Supreme Court, in fact, Honorable Supreme Court found that this is a binding framework. The MSME revival and restructural framework issued under Section 9 of MSME Act is binding. It is binding on the banks. The court held that it is binding as far as the revival and rehabilitation of MSME is concerned, and it was correctly approved by RBI by way of various circulars also. It was corrected, it was followed by RBI, it was further supported by RBI under Section 21 and under Section 35A of the Banking Regulation Act. Then, in case the banks do not comply with these notification, the Canara Bank did not comply, so therefore failure to follow the process of this MSME framework, that actually the NPA, declaration of the account as NPA, was invalid. Now this framework SMA 01, SMA 02, SMA 03, this was actually considered as binding, and in fact this was followed by, this particular framework was followed by RBI circular on framework for revival and rehabilitation of MSME dated 17th March 2016. Dated 17th March 2016, it was also kind of supported by RBI. Then thereafter, even the prudential norms on income recognition and asset classification and provisioning for MSME in that circular dated 11th of February 2020, the guidelines which was in fact given by the RBI for restructuring of MSME loan without downgrading asset classification, allowing banks to treat restructured MSME loans as standard. allowing banks to treat restructured MSME loans as standard under certain conditions. And further, in fact, there was another circular which was for MSME, that was Resolution Framework 2 for COVID-19 related stress. That was dated 5th of May 2021. And there was another circular which was Guidelines on Restructuring of Advances to MSME. Guidelines on Restructuring of Advances to MSME, that was dated 6th of August 2020. In this particular circular, in fact, the RBI permits restructuring of MSME accounts that were classified as standard as of 1st March 2020 without any asset classification downgrade, to support revival efforts of MSME impacted by the economic slowdown. And there they see in this particular framework, there was a corrective action plan which was given in this framework by Ministry of MSME. So the banks are under an obligation required to take these corrective action plans in case the MSME units are classified as SMA 01, SMA 02, SMA 03. So there is a corrective action plan that they actually is prescribed in the revival uh, framework. So this is a landmark judgment from Honorable Supreme Court regarding MSME, SARFAESI actions, revival and restructuring of MSME units. So this is, I think, can be used by the professionals. This can be used by MSME enterprises, and this can also be followed by banks giving loan to MSME enterprises. So, Ankit, any kind of questions or any kind of indulgence that you would like to have?
I think this MSME judgment is a very important one, and because the MSME threshold now is on the higher side, so it makes sense for businesses who are under stress to explore the MSME restructuring circular given by RBI, especially in light of this judgment. So it becomes even more important. Important in two aspects. One, the MSME can seriously look into the possibility of restructuring through this whole MSME restructuring circular. Optionally, it can also be used to, sometimes the business wants to buy some time to arrange those funds so that, a SARFAESI action can be delayed. And there is a possibility to arrange those funds. So that is also possible in this case. We see that banks are normally not very decisive about such restructuring arrangements. In case practically we see that once the restructuring proposal is submitted to bank, the bank would normally not respond to it or sit on it for long. I think that will also change, especially with MSME restructuring. The bank has to say no with a valid reason now to continue SARFAESI. That is also making banks more accountable.
Also, Ankit, when the bank is doing a restructuring of MSME unit, immediately after restructuring, that account will be considered as standard. Unlike non-MSME unit, where the restructuring package should work successfully for 1 year before the account can be classified again as standard. So that is a very big incentive for the banks to restructure and revive the MSME units only because their own balance sheet, their own provisioning requirement would be more friendly to them.
So it will set up a better environment. I think we have 2 3 people asking you to repeat the citation.
Okay, so I will just repeat the citation. Uh, PRONITS, PROKNITS, PRONITS versus the Board of Directors of Canara Bank. This judgment is dated 1st August 24, 1st August 24, and this judgment is in fact very important. Further, I said that this particular framework was released by Ministry of MSME on 29th May 2015, and also the RBI circulars, which are very important for this entire framework, One is the dated 17th March 2016. Second is the regarding provisioning requirement, etc., is 11th February 2020. And then regarding the COVID, it is 5th of May 2021. And regarding again the guidelines on restructuring of MSME unit, that is 6th August 2020. So these are the various RBI circulars also. So can we move to the next judgment, Ankit?
Yes, very much.
So the next Supreme Court judgment is in the case of K. Sridhar versus Rouse Construction Private Limited. It was decided on January 5, 2023, and it has also come from Justice Mukesh Kumar Rasik Vaisha and Justice M. Sundresh. Now, this Rouse Construction is a defaulter in the loan taken from Indian Bank. Indian Bank started the SARFAESI action, issuing the possession and auction notices to the borrower's mortgaged property. Now, the borrower contested the auction before the DRT, claiming the property was agricultural land and thus exempt the SARFAESI from, because the agricultural land is not covered under the SARFAESI actions. Specifically, it is exempted under section 31, subsection 1. So therefore, in fact, the DRT dismissed the borrower's claim and upheld the sale. However, the DRAT, the Debt Recovery Appellate Tribunal, required a 25% pre-deposit of the debt. The borrower directly filed a writ petition before the court, before the High Court. Now, there are various issues. Today we are also covering various judgments where the writ jurisdiction under Article 226 of the Constitution, that is also restricted a lot in many judgments from Honorable Supreme Court. In this case also, when the appellate authority, when the DRAT did not admit the appeal without the deposit, the in fact borrower directly filed a writ before Honorable High Court, and High Court quashed the auction. High Court quashed the auction, ruling that the land was agricultural based on the revenue records and finding procedural violations in the auction process. Now the issue before the Honorable Supreme Court. One issue, bypassing DRAT. Whether High Court should have entertained the writ petition when an alternative statutory remedy of the appeal to the DRAT was available. Second question before the Honorable Supreme Court was agricultural land exemption, whether the property was exempt from the SARFAESI Act under section 31, subsection 1 on the grounds of being agricultural land. 3. Whether the auction process violated Rules 8, Sub-Rule 1, Sub-Rule 2 and Rule 9, Sub-Rule 4 of the Security Interest Enforcement Rules. So these are the issues before the Honorable Supreme Court, and let us see the Supreme Court finding. As regards the alternative remedy before the litigant, the Supreme Court held that the borrower should have filed an appeal before DRAT, which was the correct statutory remedy. Filing a writ petition under Article 226 to bypass the pre-deposit requirement was improper. The High Court should not have entertained the writ petition as an alternative remedy was available. This was the first question answered by Honorable Supreme Court. Second question regarding the agricultural land exemption. The Honorable Supreme Court held that the High Court had wrongly shifted the burden of proof to the bank. Wrongly shifted the burden of proof to the bank. The burden was on the borrower to provide that the agricultural land was being used as agricultural land. It was used for the purpose of agriculture, not on the bank. The burden of proof was not on the bank to prove it was a non-agricultural. The court also found that the revenue records alone were insufficient to show that the agricultural activities were ongoing. And the photographs submitted by the bank proved that no agricultural activities were being done on the land. So therefore, the land was not agriculture. the burden of proving the particular land is on the borrower, not on the bank. So, and the rule compliances of the rule. The Supreme Court found no violation in the rules 8 or 9. It held that 25% of the auction price had been deposited within the permissible time under Rule 9, Sub-Rule 3, and the remaining 75% was deposited on time as per the Rule 9, Subsection 4, after the bank extended the payment period. I mean, we have just seen one judgment where it is said that the time period mentioned under Rule 9 Sub Rule 4 is not mandatory, that we have seen in the very first judgment that we discussed today. This is subject to the mutual consent of both the parties and it can be extended. So in this particular case, the payment was received by the bank within the extended period. The extension was within the powers of the bank. So therefore, this particular judgment is regarding the agricultural land. Agricultural land is exempt, yes, but that agricultural land must be used for agricultural purposes. 3, that the burden of proof is not on the bank, the burden of proof is on the borrower, on the owner of the land, it is not on the bank. So therefore, the particular sale was approved in this case. Now the next Supreme Court judgment that we would like to discuss is the Kotak Mahindra Bank Limited versus Girnar Corrugators Private Limited. Kotak Mahindra Bank Limited versus Girnar Corrugators Private Limited. It was decided on January 5, 2023, again by Justice Mukesh Kumar Rasik Bhai Shah and Justice Krishna Murari. In this particular case, the Kotak Bank initiated SARFAESI Act against the assets mortgaged by Girnar Corrugators Private Limited. The bank sought possession under Section 14 of the SARFAESI Act, and the district magistrate passed an order in favor of the bank for the possession. Now the respondent, Girnar Corrugators respondent, had obtained a recovery certificate from Facilitation Council under MSME. Recovery certificate from Facilitation Council under MSME. As you probably know that in each state there are facilitation councils made under MSMED Act, and probably that is on district wise following an award passed for delayed payment. Based on this, the Naib Tahsildar refused to give possession to the bank, citing a pending recovery under MSME Act. All MSME enterprises are now following this recovery process. They are moving their applications to facilitation councils as the state or the districts are having under MSME Act. They are getting orders from the facilitation councils, and those orders can even also for the attachment of the property of the defaulter. So those kind of orders were obtained by this Girnar Corrugators, and also in this particular case, the DM, the district authorities directed Naib Tahsildar to assist the bank in taking the possession, and also like the possession they should be taken by the Naib Tahsildar and should be handed over to the bank. The bank, in fact, the Naib Tahsildar declined to assist the bank, declined to hand over the possession to the bank, saying that there is an order from a facilitation council under MSME. Therefore, the possession cannot be handed over to the bank. So this was a very big question. In fact, when this particular case went to it went to single judge of High Court, and it in fact favored in favor of the single judge passed a judgment in favor of the bank, holding SARFAESI Act would prevail over MSME Act. But the division bench of the High Court, in fact, reversed the decision of the single bench, saying that the MSME would prevail over the SARFAESI Act, because MSME Act came later in 2006, but the SARFAESI Act came in 2002. So therefore, MSME Act was later case. SARFAESI was earlier. In the case of MSME, there is a non-obstante clause. Therefore, MSME Act would prevail over SARFAESI Act. Now, in this case, the other particular issue with before the Honorable Supreme Court was whether the Naib Tahsildar's refusal to enforce district magistrate's order under the SARFAESI Act was justified only because there is a order from MSME Facilitation Council. Now, the very important, let us try to understand what Supreme Court said in this case. The first dispute, whether MSME Act is overriding the provisions of SARFAESI or not. The Honorable Supreme Court said that Section 26 capital A of the SARFAESI Act, that is the section which gives priority of the debts due to the secured creditors over other debt. Because Section 26 capital E was inserted later in 2016. And it was also made compulsory for the lenders to register before SARFAESI. Once the debt and the default is registered before SARFAESI, then Section 26 capital E is applicable. In Section 26 capital E of the SARFAESI Act, the priority of the debts due to the secured creditors over other debts is mentioned, including awards under MSMED Act. Including awards under MSMED Act, that is what the Supreme Court held. MSMED Act does not explicitly provide any priority over dues of secured creditor. Unlike Section 26 capital E of the SARFAESI Act, therefore, SARFAESI Act would prevail over MSMED Act in cases of recovery from secured act. So first we discussed that the framework for revival and restructuring of MSME units, MSME enterprises is binding on the banks. But they must declare a particular MSME account by following that framework. SMA 01, SMA 02, SMA 03, and then also corrective action plan. So in case that all is done, then the SARFAESI action to sell the property and recover is having the priority. But in case that particular framework actually has not been complied with, then MSME, that is mandatory on the banks. The banks definitely can have their say in case they comply with the framework for revival and restructuring of MSME units, which was notified by MSME Ministry in 2015. That is mandatory for the banks, followed by various RBI circulars. But once the banks, in fact, follow that framework, thereafter the banks have the SARFAESI law has the priority over other claims, including MSME claim. So this is also a very important judgment. So the non-obstante clause, as I said, that in MSMED Act was actually, this act came in 2006. The SARFAESI Act came in 2002, but Section 26 capital E, which provides for the priority, that came in 2016. So therefore, Section 26E is more important for the purpose of determining the priority of the debts over other debts. Therefore, the non-obstante clause in view of Section 26 capital A is on SARFAESI and not on MSMED. Then the jurisdiction under Section 14. This has been clarified by Honorable Supreme Court multiple times that the Section 14 of the SARFAESI Act, it is only and only for executing. It is not for adjudicating the dispute. It is not the jurisdiction for adjudicating a dispute. Once the application is made to the district authorities under Section 14 of the SARFAESI Act, the district authorities are bound to help. If there is any dispute, that will go to DRT and that will not come to the court of the district magistrate or CJM or CMM. So they are not the jurisdiction for handling any dispute regarding the property, regarding title, regarding tenancy, regarding even mortgage. The only thing that this district authorities will see the documentations of the creation of security interest and the property which is mortgaged, identification of the property. So, Ankit, it is the time that we can take some questions. And today, in fact, we have to conclude it, in fact, 1 minute before 12 o'clock, because I have to join another session on real estate on 12. So, if there is any question that we can take up, otherwise, we are moving on to the next judgment, which is in the name of Haldiram Incorporation. Yes, please.
So few questions which are not exactly relating to the judgments that you were talking about, but I think I'll take them. So one is from Sanchit ji. It says that he says that in one of the original application filed by the lender to DRT, the DRT ordered recovery certificate allowing only simple interest on the principal amount outstanding, whereas the sanction letter and other contracts between the lender and the borrower allowed compound interest with monthly rests to be charged on the principal debt. So he then says whether the lender should approach DRAT to get relief basis the sanction letter terms and what the jurisprudence is regarding the same. Whether simple interest is what DRT will allow, or they can also talk about compound interest in case it is provided for in the sanction letter. That's his question.
I think once the DRT has given an order, after looking into all the loan documents, because see, whenever we file a securitization application essay before DRT, all the loan documents are also part of the essay. Once the DRT has given a judgment that this interest may be charged from the borrower, I think that judgment will survive because
Think I understand the gap here is that there is a recovery certificate issued by DRT. Now, the recovery certificate will allow for interest, but the question is that there might be an NPA date, and after the NPA date, after the liability has been crystallized, including maybe some compound interest till the NPA date, the DRT is allowing for simple interest because of in the recovery certificate. So the question here is it wrong for DRT to allow for only simple interest post the NPA period in case the sanction letter provides for compound interest? That's the question that I could understand. So this is a recovery certificate related issue.
the recovery certificate is also issued by DRT, Ankit.
Yeah. So
The
the
recovery
DRT recovery certificate can say that, okay, the liability as on the date of recovery certificate is, let's say, 100 crores plus the simple interest for the future. I
yes.
think that's the question here. That is that
See, they
simple
can they
interest,
can they
can it
can
be replaced
say
by compound interest?
they can say because see what I am trying to say, the recovery certificate is also issued by DRT after looking into all the sanction letters and sanction documents. So after considering all that and looking into the natural justice, the DRT has given an order. Like in case the bank feels that this is not a correct order and they should actually have got the compounded interest, I think this is what, according we have seen many orders where the DRT is giving a relief after the NPA date, so that the mounting interest that should not be very high.
So
So
there
this,
is some jurisprudence on limiting the compound interest and the effect of high interest. So there is some jurisprudence on that.
yes, yes, yes.
Then we have a question that in Rainbow, there's a comment rather from Rajiv Bhatnagarji. He says that, but in Rainbow paper, Apex Court stated that GVAT is created the first charge and overrides to 626E of SARFAESI. I think the rainbow paper talked about IBC.
Yes,
So
yes.
rainbow paper anyways was a very specific judgment. It has been now held by the High Court that it is not something that should be an example for any other judgment. So I think we have to put this judgment aside. There are
Rainbow
multiple.
paper, then Paschimachal Vidyut Nigam versus so that is something which is, and then finally again the review petition. So this is a matter which is, in fact, maybe it go to the larger bench, but for the time being, it is almost agreed by most of the courts that unless there is a transaction of creating a security interest, then it will become a secured operational creditor. It is not automatic. So the present consensus is that this kind of lien by any kind of state authority or central authority, that is not automatic. But if there is a charge and that is created uh, like before Section 26E, or then it is actually it is having a priority. But once Section 26E for the purpose of SARFAESI, which came in 2016, once 26E came and the SARFAESI registration has been done by the lenders, then there is no other debt which has the priority. That is very clear for SARFAESI. As far as IBC is concerned, but I have not seen this particular word 26 capital E in the Rainbow judgment, but we have seen is the IBC. In the case of IBC, now the consensus is after the Paschimachal Nigam with Vidyut Nigam judgment that it is not automatic. But if there is any charge which is created specifically by the any state authorities, and that too prior to this charge created by the secured creditor, then yes, it will be.
If there is any other question from any of our participants, they can either raise their hands or post their questions. We still have 5 minutes. So we have Hari Jakula ji. I think you'll have to make me co-host. I think I'm not able to ask him to unmute himself.
Yes, done.
Also, we have MP Srinivasan, sorry, Rachna Junjunwala ji. So maybe Hari ji, you can share your question.
Yeah, shall I ask it? Yeah, with regarding to the SARFAESI proceedings, the bank has issued an auction notice for the first time and followed a mandatory rule. Second time is also followed a mandatory. Third time issued notice, but mandatory procedure is not followed. Property has been auctioned. Now the borrower filed a SARFAESI appeal, which is a pending. So third, when subsequent times issuing the auction notice, whether the mandatory provision to be followed by the banks. Earlier, bank has filed the OA and evidence has been let in, and the same is pending for arguments. This is my question.
Thank you for coming and watching the webinars. One,
thank you.
That each sale process is independent. The banks cannot claim that in the first process they complied this, in the second process they complied with, so they have an exemption to comply during the third process. That is not the bank can claim. Each process is independent, and for each process, the entire rules as per the securitization enforcement rules then has to be followed. Yes. So the bank, in case the bank has not followed in the third process, the bank has defaulted, and the borrower will get relief from DRT.
Then property was also auctioned. Sale certificate was also issued. Now the question is, then they moved the borrower by SARFAESI appeal. Then what about OA? OA has been pending for arguments. No, as against the same borrower.
No, the same. Let's see, what we are saying is this particular application which the anyone has objected to the process, this will survive, and he will get relief, saying that the banks are bound to follow the process, and if the auction sale is not done as per the process, the sale would be considered as invalid, and then the what would be the order, that actually depends upon various other issues, whether the consideration was fully paid, whether the sales certificate was issued or not, whether there was any stay. That will be depending upon the facts of the case. But yes, my only answer is, in all the sale and auction processes, this process rule must be followed.
So yes. No Pankaj Mehta case is not applicable. 5/1/2024.
Yes.
It's not applicable. Okay. Thank you. Thank you. Thank you.
Thank you, sir. So, Mr. Srinivasan.
Namaskaram, sir.
Yes, yes. Yes, please.
Sir, provisions of pre-pack insolvency are not applicable to MSME restructuring and reconstituting of this MSMEs, sir?
No, the judgment of pro nits, PROKNITS, the judgment of pro nits versus Canara Bank is mandatory on the banks. The banks are supposed to follow the framework for revival and restructuring of MSME, which was notified by MSME Ministry in May 2015. So in case any MSME, in case any MSME account is declared as NPA without communicating with the MSME enterprise that now you have become SMA 01, now you have become SMA 02, and again SMA 03, and also giving a kind of invitation to MSME enterprise that he can avail for any restructuring and revival package. There is a revival, there is a cap that actually is corrective action plan as per the corrective action plan as per the framework for revival and restructuring under MSME. So that has to be given an opportunity to the MSME enterprise. In case the MSME enterprise is not taking this opportunity, or the proposal given by MSME enterprise is not acceptable by the bank, then the declaration of the account, categorization of the account as NPA is valid. Otherwise, the categorization of the account as NPA is invalid.
Further to add on it, I think what was also shared by you was, what about pre-packaged insolvency? So pre-packaged insolvency is available to MSMEs, but this protection or this law, this judgment that we're talking about is not about pre-packaged insolvency. It is more about the RBI restructuring scheme for MSMEs. So that is where the judgment says that the opportunity with respect to that RBI restructuring scheme should be available to the MSMEs. You can't just bypass the scheme and rather not entertain the scheme and take the person to SARFAESI. The bank cannot do that. The bank has to take care of the RBI circular. However, this judgment does not deal with what the bank should do with pre-packaged insolvency with respect to, so in case an MSME chooses to go for pre-packaged insolvency, this judgment does not give that protection against SARFAESI to that person. This judgment will give a protection to that person only if he has gone to the banks with a restructuring scheme under the RBI restructuring scheme for MSMEs.
Yes.
Thanks for clarity.
So an MSME has today then two options. One, he can go for the RBI restructuring scheme, or he can go for pre-packaged insolvency. He has both these options.
Sir, matter is in liquidation stage, sir, CIRP. Now also can we go for this thing, restructuring of MA?
Not
No.
the stage of liquidation. At the stage of liquidation, the most you can do is, I don't think a 12A is also not feasible after the liquidation. Sale of the company is the going concern, yeah. And the sale can easily happen because
directors
29A.
have any option to purchase the company as a going concern, sir?
Yes,
Sorry?
That option is available with the directors also, because
29A will not be applicable in case of MSME, or some clauses will not be applicable.
Bank has, sir, they have taken 45 crores loan. They have made it to 495 crores after making all the compound interests and all those things. The matter is pending with the DRT for orders. Still, they have invoked CIRP and now invoking personal guarantee of CD, sir.
So that is all permitted. That is all permitted to the banks. So the insolvency proceedings can also be started even if the matter is pending before DRT. That is totally separate. It can be.
That is totally okay, sir. Can we ask for this MSME rules, pre-packed condition to that?
Pre-package cannot come in at this stage, that I understand. I think the pre-package cannot come in at this stage. If you're seeing, the facts are that the company is under liquidation and personal insolvency proceedings are initiated in NCLT by the bank. The solution, perhaps, in case there is any settlement or any process.
Liquidator has not taken any action, sir. He has not given any public advertisement and all those things. So even though 1 year is over after liquidation order.
Anyway, I think it's a very specific case. Normally, this is not the normal circumstance for the liquid.
Fresh IA.
I think we can ask Rachna.
Rachna ji, in case you can share your question.
Okay, thank you, sir. Thank you.
Thank you.
Thanks for giving clarity, sir.
Yes.
Rachna ji, if you can unmute yourself and share your question, please.
Yeah, good morning, sir. This is Rachna Jhunjhunwala from Kolkata, sir.
Yes,
So I had one question, one practical difficulties which I was facing, कि जैसे जनरली कुछ लैंड पार्सल एंड आपके कॉर्पोरेट डेटर के होते हैं, उसके साथ आपका कुछ गारंटर्स या डायरेक्टर्स का लैंड भी आसपास है, जो बैंक के पास एज अ पर्सनल गारंटी में दिया हुआ है सर। तो क्या कोई ऐसा रेजोल्यूशन प्लान बैंक कंसिडर कर सकता है सर, जिसमें वो दे रहा है कि जो पर्सनल गारंटी में लैंड है, फॉर वैल्यू मैक्सिमाइजेशन यू असाइन दैट लैंड टू ARC along with the resolution plan of the CD? He is saying कि those personal guarantees containing those land should be assigned to ARC for value maximization.
So with the mutual consent, it can be done. Like what I
Okay.
understand is that the borrower is trying to ask, the borrower is trying to reach out to the bank that you assign everything to the ARC, and
Okay.
when the assignment of debt is being done, for the
Yes sir.
assignment of debt goes along. First of all,
Hmm.
assignment of debt cannot go alone. It has to go along with all the primary securities and collateral securities, even if
Yes sir.
owned by the corporate debtor, or it is if it is owned by the other than the corporate debtor. So once the debt is assigned, thereafter the bank cannot have anything in their possession. So the bank
Right.
will assign the total debt along with all the rights.
Yes, sir. But my point of view was that key as a resolution professional, sir, won't it be a conditional sort of plan? Like since we do not have those assets in our kitty and
See, like it is possible, like if the COC approves it, and
okay,
the COC's approval is important.
okay,
COC approves it, and there is no objection to any of the voter, because see there can be an objection from one person who has some personal assets also. They
okay.
can object, but if it is this is such kind of resolution plan should must have 100% voting in favor of it.
Yeah, definitely, sir.
Then there will not be any objections from any side.
Okay, okay. And at least like same options should be given to all the RAs, I think, to maintain parity also. Like if one RA is giving only for CD and other one is giving consolidated, like they should be apple to apple comparison, no, sir.
No, but that can be definitely the creditors will see in case they want to see the kind of comparison of the amounts offered. Then they should
Yes,
do
yes.
that. Otherwise, they
Okay.
will not be able to understand the comparison of the amounts offered.
Yeah, yeah.
So,
Thank
Ankit,
you.
we
Thank
have
you
to
so much,
Thank
sir.
you.
conclude. Thank you,
Thank you,
Rajnaji.
Rajnaji.
We
Thank you,
have to
Rajnaji.
conclude
Thank
again.
you. Yeah, I think we'll have to cut the webinar at this stage now. So thank you, everyone. Thank you for such an interactive session, and always a pleasure to be with you every Saturday.
Thank you very much. Wishing you a very happy Diwali. We'll again connect with you on a Sunday. Thank you very much. Thank you.
Thank you.
Saturday, sorry.